Good afternoon, everyone. An extremely warm welcome to the University of Manchester. I am Javier García Oliva, Head of Law at this institution, and it gives me great pleasure to introduce the 2024 Melland Schill Lecture. As many of you will be aware, Ms. Ollie Schill left a bequest in her will to the University of Manchester in memory of her brother, Edward Melland Schill, who had died in 1916 while serving in the First World War. Appropriately, given the circumstances, the money was used to finance a series of distinguished public lectures on international law between 1961 and 1974, which were organized by Professor Ben Wortley. Without a doubt, armed conflict is the most catastrophic mode of engagement between nations and takes an immeasurable toll in human life and suffering. And therefore, it seems fitting that a gift given to commemorate the life of a young soldier cut short by war should go towards enhancing our collective understanding of more constructive methods of managing relationships between states, including where clashes arise. Unquestionably, the need for international law and a sophisticated and nuanced dialogue around its interpretation and application remains as relevant and necessary today as it was in the 20th century. Consequently, it was an incredibly welcome development when 10 years ago, our brilliant University of Manchester Center for International Law was founded, and it revived the Melland Schill Lectures. I am indebted to all my international law colleagues for their work and dedication in the course of all these years. We have made Manchester unquestionably one of the leading institutions in this fascinating area. We are extremely proud of the outstanding intellectual contribution of MILC in the last 10 years. My warmest thanks to John Daspremont and Ian Scoville, the founders of this amazing adventure. And since so many of you joined this institution, and it's a very moving, very special day to see you back. Welcome back to your home. Some of us, of course, will remember that this new era began when John Dewar gave the inaugural address, exploring the sanctity of state boundaries, which after a gap of 40 years was an excellent way to recommence the series, hearing from one of the world experts in the field. Today, we have an equally distinguished guest, Arnulf Becker, Lorca, who is chair in public international law at the European University Institute in Florence and visiting professor at Harvard Law School. From a self-centered point of view, I'm especially excited as his work touches on a number of my personal interests, relating as it does to both constitutions and the Americas. Arnulf is at present working on the Spanish Amerindian encounter and exploring the appropriation of the law of peoples by Inca intellectuals. This is something that fascinates me in relation to legal history, the rule of law, and my own cultural roots. Arnulf has also worked as a legal advisor to the Chilean Constitutional Convention, a dialogue that I have also taken an active interest in. However, the focus of our lecture is on an equally vital theme, and is entitled Deceiving the Hopes of Humanity, Withdrawing from the United Nations. His presentation will explore the legality of a collective withdrawal from the United Nations by a coalition of states who perceived the promises of 1945 unfulfilled, and the dream of international peace and security seemingly shattered. The questions being asked are quite properly provocative, and there will be inevitably a range of reactions and perspectives on the arguments being presented. Nevertheless, it is only by posing difficult, perhaps uncomfortable questions and suggesting radical, creative, and even at times iconoclastic solutions that we can hope to achieve meaningful progress. It is no exaggeration to say that we need to have lectures and debates of this kind, as the alternative would be to accept the status quo and to resign ourselves to permanently living with the ills of the present world, without attempting to deconstruct dysfunctional systems and to build something which is much better. International law is by definition concerned with issues on a vast canvas, and the stakes are always incredibly high. The evils of violence on an industrial scale are living with entrenched injustices, limiting the lives of millions of people, are not merely hypothetical shadows, but current realities in the 2020s. While it may at times seem that our efforts to bring about change are drops in an unimaginable huge ocean, words and ideas have real power. We should not underestimate for 1 second the value of opportunities like this one, and I could not be more grateful to Arnulf for helping us to think beyond our current situation and reimagine laws, systems, and international justice as we know them. Thank you very much.
Well, good evening, and once again, welcome to the Melland Schill Lecture and to the celebration of the 10th anniversary of the Manchester International Law Centre. My name is Justina Uriburu, and I recently joined the University of Manchester as a lecturer in international law. I am a new member of the MILC family, and I am thrilled to be part of today's celebration. As many of you know, the tradition in international law of the University of Manchester predates MILC. However, without institutions, traditions, knowledge, and commitments can fade over time. MILC has not only preserved this legacy, but has also infused new life into Manchester's rich history in international law. I am also deeply grateful to have joined a community of fiercely talented international legal scholars who are also very generous and are carrying forward the Manchester International legal legacy. Their intellectual excellence is evident to anyone, but their generosity is especially evident tonight. My colleagues have entrusted me, a newcomer, with the honor of introducing our distinguished guest. Let me then turn my attention to our 2024 Melland Schill Lecture speaker, Professor Arnulf Becker-Lorca. Professor Becker-Lorca, as Javier just said, is chair in public international law at the European University Institute in Florence, and is also a visiting professor at Harvard Law School. I will not attempt to summarize the prestigious institutions where he has worked, the breadth of his publications, or the roles on scientific boards. Instead, I want to focus on the 2 marks that Professor Becker-Lorca has left in the field of international law. First, Professor Becker-Lorca has been a pioneering voice in re-examining the intellectual history of international law from the perspective of the Global South. His book, Mestizo, International Law, published by Cambridge University Press in 2014, introduced a new history of the creation and expansion of international law. Departing from the canonical accounts that focus on the European founding fathers of the field, Mestizo International Law redirected attention to the legal elites of the semi-periphery. This is, it shed a spotlight on the legal elites of those nations that, although not subject to colonial rule, were nonetheless materially and politically disadvantaged. Mestizo, as many of us call it, highlights how legal elites in these borderlands did not simply accept North American international law rules and doctrines as fixed truths. Instead, they actively appropriated Western legal ideas, reshaping them to work in their own interest. Through this lens, Professor Becker-Lorca shows how semi-peripheral actors played a crucial role in the history of international law. One of the main insights of the book is that semi-peripheral histories are not merely interesting stories that add color to the discipline. Instead, they are essential to understanding the creation and development of international law itself. The book's significance was quickly recognized with the book prize of the European Society of International Law. Moreover, since its publication, it has become a mandatory reference to anyone looking at international law's past. And second, through his academic interventions, Professor Becker-Lorca has sought to portray international law as a site of engagement from which one can open avenues for resistance. This research has examined the legal strategies of diplomats and international lawyers from the Global South who have relied on the principle of sovereignty to advocate for the distribution of resources from the Global North to the Global South. With this mindset, Professor Becker Lorca has also been an important voice in challenging third world approaches to international law from a critical standpoint. By contesting unidirectional understandings of North-South oppression, he has encouraged us to consider the roles of resistance, engagement, and agency present in the geographical and metaphorical South. He has noted that although third world combative solidarity may have on many occasions failed, even in defeat, there is something to learn. Today, Professor Becker Lorca will deliver a lecture entitled Deceiving the Hopes of Humanity, Withdrawing from the United Nations. In these very difficult times, many academic lectures and writings refer in their preambles to the current horrors the world is currently experiencing, before turning to something else. In this lecture, Professor Becker Lorca has chosen to address those current horrors head-on, with the courage, practicality, and sophistication that characterize his entire body of work. From MILC, we appreciate this opportunity for collective and close reflection. So the way this is going to play out is that Professor Becker Lorca will speak for 30 minutes, after which we will open the floor for questions, and then we will have a reception. So Professor Becker Lorca, the floor is yours.
Hi, everyone. I'm very humbled by these introductions. It's a great pleasure to be here and to see so many friends in this room and so many people that I hope will become friends in the future. So I'm very happy to be here. And I wanted to start thanking Emma, Yusra, Justina, Javier, Jean, John, Ian, and congratulations to MILC for its 10th anniversary. I hope to be here at the 20th anniversary. So Javier mentioned already that this lecture is in the memory of Edward Melland Schill, who died during World War I. And since then, there are many predecessors to this lecture that have focused specifically on the promise of international law. So when I got the invitation, I was working on other things, and I said, no, I think we should take this. I should take this opportunity seriously, of reflecting on probably the greatest promise of international law and the greatest challenge of international law, which is, as Quincy Wright spoke here decades ago, on the role of international law in terminating war, and this was during the interwar period. I tried to find the date, I couldn't, so I assume it was during the interwar. So, and the reason to start with that memory and take it seriously is because that not only the memories of World War I were behind the creation of the League, but the failures of the League were the basis of the negotiations to create the United Nations. So the United Nations, usually we think about the experience of World War II and the Holocaust, but also it had at the forefront the experiences of the failures of the League. And therefore, when we think about the United Nations, we think strongly, or we think, first of all, the very strong system of security that we identified with New York, but also there was the idea that Geneva should play a role, and Geneva was kept, and a whole machinery. The capital of peace, I took it from the website, and I kept it there because it's the idea that the promise of the League will be fulfilled if New York works well. So the idea that the promise of basic well-being for the international community will be possible if security is preserved. And the question is, so how is the many tragedies and catastrophes that we're experiencing today are linked to this promise? And we have two types, so wars, and there are plenty, so Ukraine, Gaza, and Sudan, to focus on the three probably most important of today, but very dramatic global governance challenges like global inequality, the refugee crisis, and climate change. And the question is, to what extent the promises of the League, of Quincy Wright, the League, and the UN are faring in relation to these deep challenges. And it turns out that since its founding, both civil society and states have thought about UN reform. And here just two examples. So a few months ago, only in September, there was the Summit for the Future that is the latest reiteration on old ideas about how to reform the UN and global civil society in many protests around the globe on the tragedies of Gaza. A friend sent me this. It's a petition, change.org petition on changing the UN. And if you get there, you get into a whole series of NGOs who are thinking about how to reform the UN. And what is interesting in both cases is that they focus not only in the UN, and there's lots to say about the UN in terms of an international organization. And I'm not going to talk about that. So the UN, I think it's a great institution with many problems, but there's some problems that are not so much related to what is happening in the UN as an institution, but in the international structure that the UN Charter creates. So the Charter is not only the founding treaty of the UN, but is also a basic international legal document that has been described as the constitution of the international community. And one of the things that the UN Charter does is that it has this system with two spirits, two souls that I was referring before. One is security and one is peace or well-being. And it strikes a balance between the two by creating a system of equality and inequality. And that has been at the center of the efforts to reform. So both the Summit of the Future and the Transnational Civil Society tried to reform the UN by going back to the Charter and thinking about how to redraft the Charter. The problem with the Summit of the Future, as many other efforts at reform, can you police my time, please?
Yes.
Okay, because I forgot to. So is that it has support from states, but if you read this document, 60 pages document, it's so modest. The proposals are basically reaffirming the Agenda 2030 and maybe considering, and I'm paraphrasing here, considering in the future the question about the Security Council. So it's not even mentioning expanding it or not, although during this meeting there were voices expressed about reforming the Security Council, but the document doesn't mention it. So it has supports from some states are behind, but the proposals are disappointingly modest, and they don't have support from the great powers, the permanent members. On the other hand, transnational civil society are pushing for radical reform. So there are many NGOs that are asking for triggering Article 104, I think, of the Charter and convene a new General Assembly to redraft the Charter, but it has very limited support from states and more specifically, no support from great powers. So the main question that I want to pose today is how can change happen relying, so I think that public opinion is very important, mobilization is very important, all this ideology is very important, everything is very important, but the question for us international lawyers is what can we international lawyers do and think about it? So the question is how to bargain with legal entitlements and as an exercise of legal imagination. Legal imagination is involved again. And the idea would be to, as international lawyers, ask ourselves the question. So here I have a very weird diagram with a book. This is a book project. And the only reason I brought it here is because this is my idea of an account of the history of the UN from the point of view of non-powerful states, some of them from the global south, or small and medium-sized states, how they have achieved change from 45 to today. Because let's remember, at 45, there was colonialism, there were many other things that changed over time. And to some extent, that change can be understood as happening because of the use of the bargaining power of less powerful states. And I have here one little thing here with a question mark, which is withdrawing from treaties. And the reason that there is a question mark is that, in my view, all this has happened already. Whereas this one, we always think about withdrawing from treaties. I mean, it is the ultimate bargaining tool, therefore it should be used carefully. But we always think about it as the tool of the powerful. And I thought, well, what would happen if we think about withdrawing as a tool not of the powerful, but a tool for based on legal entitlements, exercised by less powerful actors on the one hand. On the other hand, it is always understood as the tactic of the powerful that does not want to cooperate or does not want to be part of the internationalist project. And the idea would be, what if this tool is used not by the powerful, so the US, for example, not joining or the League of Nations, or what if this tactic could be used by less powerful, not to limit the internationalist project, but to advance the project? And this is basically the project, the exercise the exercise in legal imagination that I want to offer. So then the first question is, do states have a right to withdraw? And the basic answer is yes. Not as an exercise of sovereignty, but as an exercise of the invocation of two doctrines that I'm going to explain: change of circumstances and material breach of obligations. And there are many ways of argue this. One way, which I really like because it's in the title, is in light of the drafting negotiations. Representatives from states were explicitly facing the question. And in light of the experience of the League of Nations, they said, we want to have a strong organization, and therefore we should not have a clause, a provision that explicitly gives states the right to withdraw. However, and everyone agreed. However, they said, and I can quote, when member states would feel constrained to withdraw because of exceptional circumstances, the organization should not compel them to remain. Blah, blah, blah. Withdrawal or even dissolution is inevitable if, deceiving the hopes of humanity, the organization was revealed to be unable to maintain peace or could do so only at the expense of law and justice. This is part of the report that the committee approved when they decided not to include a provision. So this means that during the drafting negotiations, it was understood that under extreme circumstances, on the one hand, states could leave, and on the other, if the organization would not fulfill the promises of 45, of course, that may or should happen. And to my surprise, when I was doing this research, there's one precedent. In 1967, Indonesia left the UN. And after that, or while it was happening, different international lawyers were discussing, is this possible or not? Long story short, most of them agreed, including the staff at the UN, and Schachter was a famous international lawyer, was there, and he wrote about it. And they all agreed that withdrawing is legal, but not for the reasons invoked by Indonesia. And Indonesia invoked, the reasons that Indonesia invoked is that Malaysia was appointed at the Security Council. the consensus was that this is not an exceptional circumstance. However, what is important in following the procedures and the letters that emerged from this case is that Indonesia had a very strong legal argument, which was the UN is not fulfilling its peace obligations by bringing Malaysia, which is a country created because of colonialism, and there is this complacency at the UN. No one wants to talk about it. Indonesia was saying, this is Suharto's Indonesia, new international economic order at that time. And they say, we are upholding the principles of the UN, and that's why we're leaving. They came back the year after, and everyone forgot. But I think there is a strong precedent in that case because of two reasons. One, the consensus was that leaving is possible, and second, there was a consensus from the point of view of Indonesia, more than a consensus from the point of view of Indonesia. There was the conviction that withdrawing could be a tool not to weaken the UN, but to make it stronger. So if the argument is leaving is possible, then there are two specific legal doctrine. One is fundamental change of circumstances, which is a circumstance that is essential basis of the consent given to when concluding the treaty. This is VCLT language, and material breach of charter obligations. When the breach changes the position of the parties with respect to the treaty performance. So my argument is, and here you could choose different ways of justifying this. This is the way I would argue. I would argue that Ukraine, the war in the Ukraine, is a fundamental change of circumstances because the great power privilege is being eroded, and that Gaza is a material breach of charter obligations because under the Security Council inaction, every state around the world should ask itself how to discharge the general duties over peace and security. So in the rest of the, how many minutes I'm going to explain? 10 minutes, great, so perfect. So what comes next is explaining this, the argument of change of circumstances, a material breach, and then to say a few words about what the withdrawal would entail for the future. So the first one, the Russian-Ukrainian war. So this I don't need to explain. The conventional view is that there's a violation of the provision to use force, is not justified, and what is particular about this war is that there has been a revival of muscular internationalism, not as well, a revival, let's call it a revival of muscular internationalism, with a very strong component on accountability avenues that go from the SEC to ICJ to the Tribunal of the Law of the Sea, sanctions, loss and damages, thinking like borrowing from climate change, so very sophisticated things about lifting immunities for 1 millisecond to get assets, and then so lots of things that probably you have heard. All of this, I think it's correct. However, it ignores the charter balance between the regimes of equality and inequality, or the regime of peace and security, because this, the argument would be that this regime here applies to sovereign states. However, the security regime applies to great powers, and the security regime has, I think, different elements. Here, I'm borrowing massively from Gary Simpson's work and others to argue that the great power status is a status that is explicit in the Charter, permanent Security Council members, and in the Non-Proliferation Treaty, where the same states are mentioned as states that have a right to possess nuclear weapons. And that comes with special rights, privileges, and immunities. So the rights are the right to veto and the right to possess nuclear weapons. The privilege is the privilege to exercise violence, which is not a right, it's a privilege. I can talk more about that later if you want. And the consequence or the other side of the coin of the privilege is an immunity in relation to that violence. So in the UN General Assembly definition of aggression, there's an exception that carved out for the Security Council members. In the ICC, the ICC, I mean, the Security Council can ask for suspensions of investigations. And even the Security Council peacekeeping operations resolutions have immunity in relation to themselves. So the idea would be that you bring all this together and you can argue that there are special rights, privileges, and immunities that are enjoyed by great powers and not by sovereign states. And what that creates is it creates privileged violence. And that is reinforced by the connection between Security Council and non-proliferation treaty, because not only the threat or use of nuclear weapons is privileged. We don't know, ICJ decision, it's a non-liquid, but there's no non-liquid in relation to possession. So for those who don't know, the advisory opinion on the ICJ on nuclear weapons said, in an extreme case where the security of the state is at stake, we don't know if under self-defense use of nuclear weapon would be legal or illegal. So that reinforces the idea of the privilege. However, then the court says, in order for nuclear deterrence to work, you have to have possession of nuclear weapons, and that we're not going to say no to that. That creates a sphere of influence, and I can say more about that during Q&A, because actors who are the victims of that violence have no legal redress, not because the courts might decide wrongly, but because institutionally there's no redress in front of a Security Council member. And that creates a system of divided spheres of influence. So there's a great power coexistence. Now, what is the relationship of this to change of circumstances? Is the Russian war erodes that rule, and it erodes that rule in two senses. In one sense, because there's an accountability project, different from, let's say, when the US invaded Iraq, or different from the Cuban Missile Crisis. Because here, Russia is treated as a sovereign equal. And the idea is that that erosion could lead to an undivided great power privilege where some permanent five are excluded. So that is one aspect that the war is eroding. The other aspect, which is more important, is that the responsibilities are unfulfilled. I'm going to skip this, and I'm going to go immediately to the unfulfillment, which is the material breach. So under this erosion, let's say on paper and in fact, because nuclear weapons are still determining that legal reality, permanent members do enjoy the great power privilege. However, the great power privilege, going back again to the moment of drafting, was understood as a quid pro quo. It was understood as greater rights come with greater responsibilities. I have many quotes, but I'm sticking to one here. Broader rights are granted to states holding permanent seats at the Security Council for the reason that these are the states whose responsibility for the maintenance of peace is greater in the international community. So there are clear, and I have more quotes, and it's clear that most states that were not permanent members of the Security Council and were during drafting negotiations opposed inequality and end up accepting inequality as a quid pro quo for greater responsibilities. the erosion of the great power privilege is making the responsibilities not to be fulfilled without a change to inequality. Now, so that is the material breach. And according again to VCLT, the Vienna Convention on the Law of Treaties, you can suspend a treaty, a multilateral treaty, in front of a breach in whole or in part. So I would say what the part that a withdrawing coalition would demand to suspend is the security part, and not, it's the New York UN and not the Geneva UN. That's why I started with that. So the idea would be this, we're denouncing this section of the charter, and we want to strengthen the other one. And then I have a whole section in the paper that is maybe too complicated, but in a nutshell, the idea would be that Gaza is more than just a material breach. I mean, it's an example of a material breach, but is a material breach that illustrates not just great powers are not fulfilling the obligations, but that there's something in the design of the international law that is producing this crisis or this tragedy. So I explained very quickly an argument about two claims to self-determination and the way in which self-determination and decolonization has worked that has produced the perennial conflict, and therefore, in addition to many other reasons, international law is partially producing this, and therefore international law requires not only, let's say, ceasefire, but there's a deeper demand to international law in order to deal with this. So the idea would be that, okay, let me go back here for 1 second. So the idea would be a coalition of the willing to combat solidarity. So the idea would be that all peoples who are interested in fulfilling the promises of 45 could join a coalition, convince their states, and some states get on board in order to, in the name of these unfulfilled promises that again are peace, security, and basic well-being, demand formal request and say, because of BCLT again, we have to wait for 12 months, 1 year, and lay out the reasons, as in the Indonesian case, and demand a withdrawal, unless the duties are fulfilled. So one idea would be, this would be the conditions to actually reform. So, and we can go back to all the NGOs that have great ideas. So I don't think there's an idea problem here. So there are many proposals that are interesting. What is missing, the legal bargaining. So the idea would be, let's take the 10 best ideas, and this would be the conditions for a bargaining. I have zero expectation. This is legal imagination. Even in the wildest imagination, I don't think this is happening. So then what is the alternative? Well, the alternative is actually withdrawal. And withdrawal has it has many implications. One would be that the regime of inequality is no longer a universal rule of international law, but it becomes a rule of all the powers who do not withdraw. And the others would regard that as a non-universal treaty. The Security Council could regard that as a breach to international peace and security and kill everyone, and in the name of peace and security. But that would be one consequence. So the charter, in relation to those rules, would lose its status as a universal rule under the treaty, and would become a treaty rule applicable to only the members. And the second one would be to rethink an international regime under customary rules of international law, so none on this charter, that will take all the rules of the regime of equality or peace, so the provision of use force, of defense, territorial integrity, non-intervention, etc., etc., and would require the withdrawing states to be proactive in what an international order, a new international order would mean based on the respect of sovereignty, non-intervention, but also in what cooperation could mean, again, going back to the great challenges that we're facing, from war to climate change, the refugee crisis, and inequality. Thank you.
Yes, yes. Well, thank you for that, Professor Becker Lorca. It was thought-provoking, energizing. Yeah, lots to think about. So we will now take, sorry, I need to look at the time, 20 minutes for the Q&A. If you have a question, I would be really grateful if you could introduce yourself before posing the question. So, Professor, no? So I do not know if we have an extra microphone, but we can circle it around.
I don't want to be the first one to know the question, but you pick mine. I will make use of my position. Arnulf, thanks for traveling to Manchester on this very important anniversary. Obviously, I see the rationale of coercing the UN, actually, to use a UN word, of coercing the UN through the idea of a state withdrawal. I wonder whether we as scholars, we could even push it further at the level of legal studies. Should we do something similar as legal scholars? Shall we just remove the UN from our syllabus? I mean, if we follow your argument, for instance, the one on material breach, could we say we no longer want to teach and research an organization which is complicit and which obfuscate mass atrocities? And so should we ourselves silence the UN? I don't think this is very polemical, because I don't think it's ever been natural to put the UN at the center of international legal studies. We had international for centuries without the UN. I don't think it's the mere fact it's created by a treaty does not justify its centrality in international law curriculum. So I don't think it's polemical. We could leave it to IR specialists, peace studies, and so on. And you mentioned a precedent for state withdrawal. I think we have a precedent for this epistemological withdrawal I'm speaking about, which is the EU. At the outset, the EU was studied by international lawyers, and someday we decided not to study it anymore and not to include it in our syllabi. So it was once an international topic. So yeah, why not also withdrawing? I mean, to push your reasoning further, why not withdrawing it from our syllabi?
Shall I gather questions, or do you want to take it one at a time, Arnulf? Okay, I'm going to pass it. Okay, 3 is a good number. Vin?
Hi, my name is Wim Buller. I'm at Maastricht University, but I used to be here for a short while, and I got my PhD at the UI. So anyway, I just had one question, but it's about a clarification. Well, thank you also for a very fascinating presentation. It's about when you were describing the Russian situation. And you said that the difference between that and the situation in Gaza, or at least one, is that it is treated as a sovereign equal. And I'm kind of trying to figure out what you meant by that, as if there was one element missing. In connection to that, would you also say that would it be possible to reverse the situation and treat Gaza basically as an example of a power privilege, even though it's the power is exercised more by another permanent member of the Security Council, and to treat the Russian situation as a material breach?
Wonderful, thank you very much. And here, the third question.
Okay, I'm Brian, and I'm a student here at the University of Manchester. If some countries did withdraw from the United Nations, do you believe that a rival organization similar to the UN would be formed by those countries who had withdrawn? Alternatively, do you think the UN would become a rump organization, or even if the countries would no longer support the idea of transnational cooperation? And if we don't talk about withdrawal, do you think it is probable for the UN to admit more countries to become members of the Security Council or become the permanent members of the Security Council?
Thank you very much. I'll hand the mic back to Arnulf.
Thank you. So I understand what you're saying, but I would be completely opposed, because I think we should study the bad things in order to get them. And I think, I mean, I think the UN is New York and Geneva, or Geneva, New York. And to me, the UN is self-determination, it's friendly relations, is the new international economic order, and this. And this is all, so my project is to focus on the bargaining or the balance or the relationship between the two. So I don't have great expectations of anything. I just want to lay out the conditions for a better bargaining. And therefore, unfortunately, we should teach, and it's our responsibility. But I think, I'm pragmatic about it. So if epistemic withdrawal leads to something, let me know, and I sign to that. So I'm very pragmatic. So let me clarify. Okay, so I don't like the great power privilege. I'm not trying to, and in that, this goes maybe back to that. So I would like everyone who ends up teaching this part, which is not, there are not that many articles about it, with great power privilege in Google Scholar. So okay, so I'm not unapologetic about that. However, since that is a rule on the charter, and that Russia is one of the great powers, my point is that Russia is treated as a sovereign state and not as a great power. The connection to Gaza is the following that I didn't mention. Under a sphere of influence, each great power decides whom to protect under its umbrella of immunity, and Israel is protected by the US. So that is the connection of the great, the war from the point of view of the great power privilege. And I think it's maybe I should say something in the paper about that. So that would be the difference. Russia is treated as a sovereign state. Israel is not treated as a sovereign state, or a little bit. It's treated, you go to the ICJ or the ICC and everyone is excited. And I don't get excited because I know that all those rulings will be unenforceable because they will get to the Security Council, and like the Nicaragua case. So I'm very ambivalent because I love the Nicaragua case. I still remember the Contras and all those things, and I think great doctrinal developments happened with those decisions, but we should not forget that they were never enforced. So in terms of human suffering, we're not getting there. So I'm fine with saying, okay, this is not for human suffering, and let's enjoy ourselves as international lawyers and get excited about the ICJ doing all these cases. But what I don't like is the idea that we're doing something about the human suffering. So we're not. The last comment, I think again, I really like the UN. So I wouldn't like it to be. You're rolling your eyes. I mean, I think you're right, but I have. So I don't know if John is here, but he had a hat that said "Make International Law Great Again." That represents me. So I think there is a promise there. So I don't think, so let's say for some weird reason this happens. I don't have an expectation of a Westphalian moment or anything. So my idea would be, this is so much like the Jawi. So the Jawi New International Economic Order, there's nothing revolutionary in that book. In that book, it's like, he says, the third world is like a union, and a union should get a better bargain, and they should hire a good lawyer and do it. So that's my goal here. So therefore, I don't, probably I will have in the paper, I will have to say something more about a future, but let's say there is a future, I think would be the same. Some balance will have to be struck between bigger and smaller states, and no one will be satisfied. It will be a political moment. Let's see.
We definitely have time for a second round, so, okay. Let's start with Ian. Here
you go.
Then Rebecca, and then in the back. Yeah.
Thank you so much, Arnulf, for something that could keep us in the same room for days, not just 20 minutes. I have reactions in maybe 2 points. My first point is a bit of I would like to question the idea that this is a radical proposal for reform, and suggest that it's still a modest, and I think it shines through the idea that you like the United Nations. It's still a modest proposal for reform. My question is, wouldn't a call for radical change require radical legal reimagining, or an exercise of radical legal reimagination, one that goes beyond a state-centered approach, beyond institutional structures and creatures that we have in mind? So this is the first question. And more than this, I think what really strikes me as powerful in your proposal is not so much the change that it calls for or that it hopes for, but rather the narrative that it creates for the present. So, and here we see how futurist moves are really a narrative technology to govern the present. And it seems to me that what makes it powerful is that it makes credible an act of resistance for less powerful states. Or should we start saying the majority world? So it makes credible an act of resistance that serves to highlight, denounce, and you say it in your paper, the unequal regime behind the privilege. So isn't that the power of what you propose?
Okay, great. Here we go.
I think this might chime some of the things that Rebecca said. Is there an alternative to sovereignty?
Drop the mic.
In the back.
Yeah.
My name is Barak Al-Fajal. I'm a PhD student at Manchester. Thank you so much for a very interesting take on this. I haven't really thought about it this way, but I become a bit concerned when Professor, you spoke about the United Nations becoming prominent in 1945, at a time when colonialism was very prominent and we needed a way out of it. How do we deal with modern colonialism that is happening today, where if we have states deciding to withdraw from the UN, then less powerful states cannot do this because there is pressure from more powerful states. They're being put in a position where they have to follow the herd, because if they don't, then we cut economic ties, then we try to pressure them into not doing this, and then it becomes that you're the only one being singled out for doing this. So how do we deal with this idea of modern colonialism? Thank you.
Let me start with Barak's question. So I suggest everyone to read a beautiful book about the Afro-Asian coalition. that was behind the Declaration on Self-Determination. So self-determination was not a concession, it was a struggle, and the struggle happened with ideology, war, and everything, but also was a diplomatic struggle at the UN. And actually states, Afro-Asian states, the Afro-Asian coalition was crucial to get self-determination. That's why I think we should continue working on the UN, unfortunately or fortunately. But emphasize those stories. Again, if you take a traditional conventional textbook, that story is not there. So what I learned from that story is that there's more power, or power is not it's fluid. It depends on material conditions, but also on ideology, on many dimensions. So if this would be 1990 something, this would make sense, this thing, or maybe it would, depending on the year. But I think so let me be honest. So all these things are happening, the second slide, and I don't see there are so many ideas about what to do, but hoping that so I'm very dissatisfied with the hope that many international lawyers have on a little ICJ ruling. I find it morally perverse that for us international lawyers to feel good about it is predicated upon massive atrocities. And the best we can hope for is accountability. And Russia, Ukraine, the number of that's why I started with Melland Schill. He died. All those deaths, and we're happy because maybe there's loss of damage or a ceasefire or whatever. So I think that under normal conditions, there's so many problems with a proposal like this, but these are not normal conditions. So that is the okay. So this is not radical. I'm not a radical. I'm fine with reform. Because I mean, so I work in a critical legal tradition where I think what one learns is that the moments of complete openness, let's assume after political upheaval, war, peace, are moments of constraint rather than openness. And rather legal, I mean, we had World War I, World War II League, UN are basically the same. You go back to Westphalia, basically very similar. The Spaniards arrived to a new planet, not that different. So maybe it's my lack of imagination, but I think it would be more, I mean, I find it more useful to work now borrowing from Levi-Strauss and others, doing bricolage rather than engineering, because engineering never happens or only happens sometimes, but the engineers are the powerful. The bricolage doers are the less powerful. So that's my thing. And I like what you said about present. So that's the other thing that I was trying to react to, the idea that we strive for a ruling in, you told me 10 more years on genocide, and
Just
then
a
a guess,
Just
a
a
wild guess between 5 and 7 years. So 5 and 7 years, we're going to celebrate a great ruling. I find that morally perverse, and therefore I'm doing this little thing. Sovereignty. This ties to my answer to self-determination. I think that when you learn international law for the first time in a non-Westphalian country or not in the peripheries of there's a very psychotic feeling, because on the one hand, you read a textbook that says sovereignty is bad, we're going to teach you how to overcome sovereignty. On the other hand, your country gained sovereignty, and then you say, how to reconcile this two. So I think we should not fetishize internationalism or nationalism. We should criticize all of them, be very aware of. So I don't think there's an alternative to sovereignty, and we should continue studying sovereignty, statehood, boundary disputes, blah blah blah. But I think for me writing this thing, there are many lessons, but one that I want to consider for readers that has been a slow digesting of an insight, which is international lawyers tend to create let's say an artificial conflict between the sovereign and the international. The more international law, the better the internationalism is, and vice versa. And I think that is not useful, and that we should start to, or many have done before, to see, because of our normative political commitments, where do we see that there's an injustice or a political controversy, and think what are the tools both of internationalism and so international cooperation and nationalism, sovereignty, that play out concretely. And this goes back to what I said before about Gaza and Israel and Palestine and Israeli. So I don't think in that case you can say internationalism will solve it, nationalism increases pain. So we have to disaggregate both and choose according to our normative commitments.
I know we're over time, but perhaps we want to do a final round of questions. Yes, over there in the back. Sorry, Emma, yeah, and then here in the middle.
Thank you. I'm a master's student within the Global Development Institute, so sorry for my lack of legalese. But I was just wondering, you mentioned the range of crises that we're facing, and I was wondering if there'd be a legal argument that the climate crisis constitutes a fundamental change of circumstance, and that could justify a withdrawal. Thank you.
And then here in the middle. Yeah, it was, yeah.
Hi, my name is Yasser. I am a first year PhD student here at Manchester. My question is to do with withdrawing from the United Nations. And from what I understand is, and given how the states have been treated over a period of time, the weaker states, do you think that will withdrawing from the UN will be without consequence for such nations? For example, the aggrieved nations are the ones who haven't gotten what they needed from the UN in terms of protection, in terms of other treaty obligations that stronger countries had. So my question is, wouldn't be of consequence for them? Because it might just make the work of the existing type of nations easier. Thank you.
Thank you very much for the lecture. My name is Pat, and I also graduated PhD here at Manchester. I have two small point based on your presentations. So the first point would be kind of I have to say under the UN Charter, there's no clear provisions about withdrawing from the UN. So do you think that there would be kind of the behind intentions on the back that they don't want any state to withdraw itself from the UN? That would be my first question. And another question is that have you ever think about kind of the consequences after for maybe for any state to withdraw from the UN, whether that it will have other effect, for example the state that gonna be the P5 member that they also have the privilege. However, that whether if they would like to withdraw itself from the UN, would that be any places that reach some that actions. That would be my question. Thank you.
Thank you.
So in the same order, so the idea would be that the climate crisis is one of the so I focus here on Gaza. The climate crisis would be a material breach rather than a change of circumstances, because the idea would be that the privilege that come with great power came with responsibilities of basic well-being, and those are not fulfilled, and therefore there's a material breach. Weaker. So the two of you. So let me emphasize something that I said and emphasize again. So my argument is more an intervention in relation to the structuring of the UN rather than the UN as an organization. Therefore, is an attempt to redraft the constitution of the world. So in that sense, the idea would be that weaker states in the current design, architecture, international legal architecture, they are subject to rules of equality that apply only to them, and in that sense, they're unequal in relation to the great powers. Again, that design was based on the idea that those greater rights by the permanent members were demanded in order to have peace and security and basic well-being. Now, weaker states are not getting those. And even the basic rules that were at the center of the sovereign equality regime, limited self-defense and the provision to use force, no longer have the power that, let's say, symbolic power that it used to have. So it's not that the world is working well in those terms, because as I mentioned in the slide, it's climate change and these wars. So I don't think that, and therefore a withdrawal has the intention of forcing that bargaining to be revisited in order to either, let's say, continue with that inequality, but now they have to contribute more. So maybe I should say it in the text. So something that makes me very mad and makes me to spend time and write this is the killing in Paris. When people say, "Oh, Paris great," and I don't know, Bono Box was celebrating from YouTube. I said, "What is going on?" So Paris to me is terrible because it's the end of common but differentiated responsibilities. So, and that again goes back, and common but differentiated responsibilities goes back to 1992, the Rio Summit. That was a big North-South bargain. So those are the things that should be revisited. So my view is very simple. Maybe I should say it in those terms. These five are getting the privilege and they're not paying for it. And they should pay with climate change rather than nationally determined commitments. They should pay somehow. They should say, okay, how do you want to pay? Or we get rid of it. And the weaker states would say, we denounce now the rules of inequality because you're not paying for it. So in this diagram with lots of things, I have many examples where the NGOs and smaller states. So this is even before COVID. So before COVID, now there are negotiations of a new global health treaty. Before COVID, there were negotiations of a global health treaty. The idea was to create a global fund to do research and development of neglected tropical diseases. So a parallel system to the IP protection system. The US killed it, not Trump, this is before Trump. Obama, the Obama appointee. So everyone was saying it. I went through the proceedings and I found it and I have it. And I published it, so if you want to quote the quote. with this say, we are not supporting a treaty that creates a global tax. And that is the position of not every great power, but most great powers. They want a strict interstate system and not a redistributive system. The idea of 45 was not a redistributive, but had this bargaining that is redistributive. A bargain between the rules of equality and inequality. And that, I think, is not radical, going back to Rebecca's question. It's not radical, but is revisiting the basic bargaining.
Thank you. Thank you all for your engagement and questions. Please join me in a round of applause for Professor Becker.